Hi everyone, it's Wayne Jones, the course coordinator for Australian Employment Law. This is the third part of the material for week 9, and I think this is quite an interesting topic. It's discrimination and victimisation. Now, most of us have heard about anti-discrimination legislation in the past, but for some of you it might be the first time that you're hearing about the victimisation provisions which appear in the Fair Work Act. And essentially we're talking about a situation where an employee receives less favourable treatment, in fact might even lose their job, because they have insisted on enforcing the rights that are given to them under the Fair Work Act. So let's have a look at the material together. It's Chapter 14 in Stewart's Guide to Employment Law, and if you want to do some further reading, have a look at Creighton and Stewart at Chapter 17, 17.4 and 17.5. Your textbook comes up with a neat little definition at the beginning as to why what anti-discrimination laws seek to do, and that is promote the principle of equal opportunity by prescribing discrimination on the basis of certain characteristics. So in other words, promoting some equal opportunity in the workplace. You'll see in the reading that there are two bodies which administer the laws in this area. They are the Human Rights Commission, and in the various states, for example in Queensland, there are other discrimination commissions. So quite a bit of law. At the Commonwealth level, your textbook refers to these acts: the Racial Discrimination Act, Sex Discrimination Act, Disability Discrimination Act, and the Age Discrimination Act. Note all the different years that they have been either introduced or updated. So the Racial Discrimination Act going back to 1975. The textbook also lists the state legislation. The one that I'm familiar with is Queensland, but you should have a look at the legislation in your own state and territory. You're going to find that they deal with a lot of the same sort of territory. There is a table at paragraph 14.4 in the textbook which lists some of the characteristics that are the basis for a discrimination claim. Broadly, you're talking about race, gender, sex, age, etc., but check your individual act. Note two things. One is it can be a breach to discriminate on the basis that you are a friend or an associate of a person that has one of those attributes. And the second thing, which is often overlooked by folk who are talking colloquially about discrimination, they'll say that someone's discriminating against them. There's a couple of things that need to be proven before discrimination is actionable under the legislation. So on the one hand, a person may be quite rightly saying that they've received less favourable treatment. Secondly, that they think that they've received less favourable treatment because of an attribute, and let's choose, for example, race. But there is a third limb that needs to be established, and that is it needs to be in a particular area. So you'll see with most of the legislation there'll be a list of areas in which you are to receive less favourable treatment based on one of those attributes. And the two examples, or three examples that I've put up there are: you can't receive less favourable treatment because of race in the area of employment, education, accommodation, and there's a list of others if you have a look at your legislation in your own state. Note also the comments regarding direct and indirect discrimination. The textbook provides a number of examples, a number of case examples, but it's not an easy thing to get your head around, and nor is it an easy thing to necessarily predict whether there will be a finding that some discrimination has been indirect. Direct, pretty easy to see, treating a person less favourably because of those attributes, just direct discrimination in a particular area, direct discrimination. Indirect, making a rule which indirectly excludes or affects a person. And I think the example they give you in your text is height. If an employer said, we'll only hire persons over 180 centimetres in height, there's going to be a much higher proportion of men than women who are eligible. Therefore, that has the effect of indirectly discriminating against women. Notice also there the interesting case of Australian Iron and Steel against Banovic, where even applying the test of last on, first off was going to tend to be more prejudicial to females. So it's interesting, always worth an argument, but you're never quite sure whether the claim of indirect discrimination is going to get up. Okay, next, the legislation that we've looked at also deals with harassment and vilification, but the big ticket for us in employment law is always going to be around the area of sexual harassment. Note the definition which is applied there. It's drawn from section 28 capital A of the Sex Discrimination Act. Conduct of a sexual nature, so it's not necessarily bullying, but there has to be some sexual nature to it. Reasonably expected to offend, humiliate or intimidate. Not just touching, also involves comments, display of materials. And my addition to what appears in the text there is, these days it's often something which appears on a computer. It could be an offensive or a trail of offensive sexual emails that's sent to a colleague, or it might be displaying something on the computer screen. So don't discount that. I noticed the authors talk about putting up offensive pictures, pornographic material in the workplace, physical things, but certainly don't discount what happens on the computer. Note also the comments that are made at the bottom of 14.6 in the text regarding failing to deal with behaviour. There have been a series of cases in the past where employers have argued that they've done everything that they reasonably could to try and stop the behaviour in the workplace. And I recall one particular case where a bank said, look, we offered training to employees on this topic and we've got a manual. And the reality was that the manual simply sat on the shelf and it just wasn't being complied with. So failing to deal with the behaviour, once, particularly after a complaint has been made, is often the grounds for discrimination in the workplace. Okay, there's that exception. We're now at about 14.7 in the text, employers' affirmative action plan and policies. But bear in mind that warning I've just made. If the policies just sit on the shelf, they're not actioned, they're not the subject of ongoing training, for example, they're not likely to be of much use in defending the employer. Note also the comments regarding a genuine occupational qualification for a job. That's a boundary that's pushed quite a bit. There really needs to be a genuine reason that a person, for example, needs to be 6 feet tall as an occupational requirement. And they're often tested. Those types of first blush requirements are often tested through the courts. Notice also the exception around religious bodies, protecting their own doctrines and beliefs, the rights and privileges given to pregnant women, and the fact that it is possible for an employer to apply for an exemption. Particularly, for example, you'll see exemptions in place to hire only Indigenous people to try and raise the number of Indigenous people in the workplace. So, an application might be made to advertise for a position asking only that Indigenous people apply, that sort of thing. So exemptions can be applied for, and that's not unusual. So what happens if there's a breach of the discrimination laws? Well, first and foremost, if it ends up in a court, it is possible for orders to be made that costs follow the cause. So costs will normally be awarded to the party that's successful in the action. The sorts of orders that a court will make, declarations, restraining orders, orders requiring the employer or sometimes the employee to do something to redress the behaviour. Often that's, for example, the ordering that the employer will run courses on appropriate behaviour in the workplace for the next 12 months. There could be orders made that a person who's been dismissed be rehired or reinstated, or if they've failed to get a position, and it's one that they could reasonably have expected to be appointed to. They might even be ordered to be hired by the company. Note the comments in the text regarding the amount of compensation that's being ordered. It is not capped in most states. There is a reference to Western Australia and New South Wales capping their damages, but for other states it's often simply not capped, and large sums are now being commonly ordered to be paid in sexual harassment cases. All right, well then the next big topic in the textbook is the one that relates to the Fair Work legislation. We've just been talking about other legislation generally dealing with discrimination, but the next relates to general protections under the Fair Work Act. And have a look at Part 3.1 in the Fair Work Act. There's a short extract of it on your screen there, starting with a guide to the use of the section, meaning of employer and employee, and then after application, discussions around things such as workplace rights, industrial activities, and various other protections, including the discrimination we just talked about before. The application of Section 3.6, Part 3.1, talks about it applying to all employees, employers and employees, independent contractors and associations if one of the connecting factors is satisfied. And so we're back to where we were at the beginning of our 12-week discussion on employment law, thinking yet again about jurisdiction, thinking yet again about the constitutional issues. The connecting factor that makes these protections fairly broad is the constitutional corporation. So the connecting factors are these: constitutionally covered entity, a company, a Commonwealth agency, or a federally registered union or employer association. So there's that Commonwealth thread that you often see when the legislation is trying to spread its influence. Involves advising, encouraging, inciting, or seeking to coerce a constitutionally covered entity, so as we saw above, to take or not take an action in relation to someone else, happens in a territory or the Commonwealth, or is taken by a territory employer. All other conduct in a referred state. So it's as broad as it could possibly be, the only exception being the one that we're used to now, and that is probably doesn't apply to state public servants. Now, some of the terminology, they refer first of all to adverse action. So what's the meaning of adverse action? And there's a table. If you go to section 342, you'll see a table, short extract of it there on the screen with the first couple of items. An employer against an employee, the employer dismisses the employee or injures the employee in their employment, or alters the position of the employee to the employee's prejudice, etc. So have a look at 342 in its entirety. So there is a definition for what adverse action is likely to mean. Coming back to that list of definitions that appeared, injury is to suffer a compensable harm. So in other words, something that you would ordinarily associate with a claim for damages. Probably the best example would be to lose your job and not be in a position to earn your wages. But it can also mean to alter a person's position to their prejudice. So it's not necessarily an injury, but it's an adverse affection or a deterioration of advantages, and that's been held to be in the past even something like a loss of status or moving a person from one part of the organisation to another. Dismissal includes constructive dismissal, but note that there is a carve-out, and that is it's no good trying to bring an adverse action for something that is action that's allowed under the Fair Work Act. And so, of course, you saw some examples provided in the text around withholding pay, withholding strike pay when there is industrial action happening. That's not something that would fit the definition of adverse action. Adverse action in relation to workplace rights. So a right is workplace rights an entitlement to a benefit, and something where the person has a role or a responsibility. So they've got a benefit, a role, a responsibility. Under workplace law, under workplace instruments, including an award or an agreement. So a benefit, a role, a responsibility that's allowed for under law, under a workplace award or under an agreement. But note again the carve out that contracts, a right that a person has pursuant to the terms of a contract is not a workplace right for the purpose that we're talking about here. Workplace rights, again, defined in 341(1)(a), the capacity to initiate or participate in a process or a proceeding. So you have a right if you could bring an action, or you could ask Fair Work Commission to intervene and help to conciliate a question. So if you've got something that could take you to Fair Work, to the Fair Work Commission, I'm thinking of an example off the top of my head perhaps. You've had an argument about whether or not something, whether or not you should be entitled, whether you should be working particular hours or not under an agreement, and you'd like to go to the Fair Work Commission. So you have a right to bring something before the Fair Work Commission. But also includes going to court, and that's logical. If you can take something to the Fair Work Commission, you can probably head off to court as well. A workplace right, the rights that you exercise when you are making an enterprise agreement. And remember, people had the rights to be heard regarding whether a group or whether a group of employees was fairly chosen, for example. So making an enterprise agreement, the steps along the way. The various requests that we've talked about under the National Employment Standards. So the right to request a variation to your hours under the National Employment Standards. They're all workplace rights. Some of the examples that are given in the textbook where a person has complained about their own treatment, or where they've complained about the treatment of another, and then they've suffered some sort of adverse action by the boss. Where they've refused to work under sub-award conditions and suffered some sort of adverse action from the employer. Taking or requesting leave, seeking to return to work after they've had their parental leave, refusing to work unreasonable overtime, or even pursuing a workers' compensation claim. Case examples have been provided in the textbook for all of those at 14.13 in the textbook. So have a look at some of those example cases. But you can see from those examples the flavour of what's happening here. A person has exercised, quite reasonably, they've exercised a right that they have either under an industrial instrument or under the law or under an award, and instead of the matter being dealt with as you'd expect under that instrument, they've suffered some sort of detriment, right up to and including perhaps dismissal. Adverse action also relates to industrial activities. So it's defined, or industrial activities are defined in section 347, and there's a brief extract from 347. Have a look at it in a bit more detail, but protected action does apply to people who take or become involved in industrial activities such as are defined there. And that includes even becoming a member of, or becoming an officer, or just a member of an industrial association. Now, adverse action also includes coercion and undue influence. They're the sections, as I mentioned in the text, section 343, a person being coerced to exercise or not exercise a workplace right. 348, person being coerced to take industrial action. 344, slightly more subtle, undue influence or pressure to make an agreement, as is contemplated by the National Employment Standards. So remember we talked some weeks back about flexibility arrangements, and they really had to be voluntarily entered into, because remember, you could also, with reasonable notice, back out of those arrangements as well if you wanted to take different a different approach to what was in an award or an agreement, you could make a flexibility arrangement with your employer, provided you were still, you were no worse off and provided you had the opportunity to back out. Well, it's got to be done voluntarily, and that gets mentioned in 344. 345 and 349, knowingly or recklessly making false or misleading representations about a workplace right or an obligation to be involved in industrial activity. And the sort of thing that you can imagine there would be people or employers or their representatives falsely making statements about what the workplace instrument means. 350, an employer or a principal inducing to become or to remain in a union or to perhaps not join a union. And the examples that were given there related to misleading workers into thinking that they were required to be a union member before they could get a job on site, or telling a contractor that they have to make some sort of an agreement with the union before they can get work on the site. And I'm thinking of those site agreements, for example, where the contractor agrees that they won't offer wages below those which are being offered under the enterprise agreement, for example. Those sorts of things, getting the contractor to believe that they have to do that before they can participate in the project would be unlawful. The Act also refers in section 351 to discrimination by employers. And as we talked about at the beginning of this discussion, with the state and the Commonwealth legislation around discrimination, there are defences. Have a look at section 351 in its entirety. You'll see there 351(1), an employer mustn't take adverse action against a person who's an employee or even a prospective employee because of the person's race, colour, sex, sexual orientation, age, etc., etc. And the defences were the ones that we talked about before. So if it's an inherent requirement of the job, for example, that the person be of a particular religion, because it's perhaps it might be a particular religious school and they're looking for a religion teacher. They can say, well, it's an inherent requirement that you know what you're talking about. And generally, religious institutions, again, are entitled to take action against the staff to avoid injury to religious susceptibilities. So breaches of, the tenets of their church. Another one I think that's quite interesting is this one about temporary absence from work. It doesn't get a lot of mention in the text, but does come up quite a lot. Section 352 says that an employer can't take adverse action against an employee just because they're away from work for a short period. Now, if they provide the required doctor's certificate, medical certificate, whatever it is that they're required to produce under the agreement, then that's not deemed to be a temporary absence. If a person's away for more than 3 months, or 3 months in a 12-month period, and they're not actually on paid personal carers leave, then they are said to be temporarily absent. When a person is temporarily absent from work, like that, then the point was that they're defining what a temporary absence is. Well, what happens if there is a breach? Now, in the case of some of the breaches that we've seen, the most likely thing is that the party will bring proceedings. But there's a couple of things that might need to happen first. So section 539 says proceedings are commenced in the Federal Court or in the Federal Circuit Court. But before you get to there, section 372 and 374 says it might be optional for you to have a conference with the Fair Work Commission. Now, whether that happens a lot in practice is another question, but it is an option that parties might decide to have a conference first. Section 365 and 368 says, well, It's not optional, but it's compulsory if it's part of a dismissal claim. So before you can go any further, you need to try and conference and see whether the matter can be resolved. So you've got that time limit that applies to all dismissal claims, and it's 21 days to request such a conference. And you can't go on to commence proceedings in a court. The court won't advance your case unless you have a certificate from the Fair Work Commission saying that all reasonable attempts have been made to try and resolve the dispute. And if that doesn't happen, then you can move on to proceedings. And the outcomes of a court action for these types of victimisation actions, you might be, the order might be that a job be offered, reinstatement of a dismissed worker, or uncapped damages for loss, which includes those sort of amorphous things, humiliation and distress. And interesting though, and certainly frightening for an employer to think that the damages are completely uncapped. Again, another really interesting thing about these prohibited reasons cases is the reverse onus of proof. So in other words, how it works is like this. Once the claimant raises one of those possibilities that we saw before and says, well, it's a prohibited reason. It was because I asked for flexibility in my working hours. Because I demanded my holidays, because I simply asked for whatever it happens to be. Although often it can be for things like I've complained because I complained about the behaviour of a co-worker, or because I complained about the behaviour of a boss. It is sufficient if just one of those reasons is the reason that the adverse action was taken. So whether it be dismissal or loss of some benefit, what have you, it's sufficient if it's just one of the reasons. And it doesn't have to be the main one, which is interesting. So once that's raised as the issue to be determined, then Section 361 says it's now up to the defendant to prove that the action wasn't for a prohibited reason. Now, the only exception to that gets a mention in your text is if you're chasing a temporary injunction. If you're asking for an interim injunction while this is sorted out, then you might have to raise, the applicant might have to raise a triable issue and have the court determine that yes, there is an issue to be heard. There's a prima facie case. But generally speaking, the defendant's got to prove the action wasn't taken for a prohibited reason. So if you've got somebody who's dismissed and they raise a whole list of possibilities as to why they were dismissed, the employer might well say, well, it was because of their poor performance. And if in the middle of all that, though, one of the reasons that was taken into account was allegedly because they'd had bad blood, there'd been a complaint made between one person or another, then the claim is made out. Two really good cases to look at, and I would urge you to have a look at both of these. The NTEU against RMIT. Now that's interesting because the Vice-Chancellor of the RMIT had to go into the witness box. There'd been some long history between two reasonably senior employees, and I think everyone agreed that there had been complaints to and fro, and I think it was also the case that they were probably snagged by the inevitable email that manages to surface. But in NTEU and RMIT, I think they found that the Vice-Chancellor gave very honest and credible evidence, so much so that the VC just refused to rule out the possibility that the academic's complaints about bullying by his supervisor hadn't played some part in the decision making around dismissing him. Essentially, they were looking for a pool of people to make redundant because of financial issues, and this man found himself in the pool, partly because he was a good choice, partly because there'd been such a lot of bad blood between him and the other academic. Now, the other one that's really interesting is this board of the Bendigo TAFE at Barclay. Again, have a look at the case in a bit more detail than appears just in the text, but essentially it was the argy-bargy in that one was about whether or not the person honestly believed that acted for a permissible reason. So here the CEO gave uncontested evidence that they took the step because she really did believe that the employee had breached his employment obligations in the way that he dealt with something by not reporting allegations of alleged misconduct, instead sending out an email to all and sundry at the TAFE asking if anybody else knew of any examples of similar behaviour. It went, first of all, it went against the it went against the TAFE on the basis that I suppose that they were talking about whether or not it was dealt with on an objective basis. The majority of the full court said it wasn't enough that the employer believe it had acted for a permissible reason. If the reason lay in something that was actually lawfully done by the employee, then it was sufficient. So, in other words, if the person got it wrong, even if they had a wrong belief, and they just got it wrong, that would allow the section to be triggered. But that went on appeal to the High Court, and the High Court said, no, it's not really on an objective basis. If the decision maker gets into the box and they are accepted as quite reliable and they did not act for a prohibited reason, so you could sort of, what you're asking is what's going on in their head. The evidence is about what's going on in their head. It's not objective at all. If that's the case, if it was accepted as reliable, then that would discharge the burden of proof. And that'd be the end of the matter. So the decision would not be one that was taken on the basis of past behaviour, and so it wouldn't be for a prohibited reason, provided that person was able to convince the tribunal that it wasn't. So quite an interesting case, really. Also makes the point that's mentioned there in the text that the employee shouldn't be considered to be immune from disciplinary action just because the act complained of occurred in the course of their union activities. So two really interesting cases that certainly spell out the boundary of this discrimination and victimisation. Now, the growth area, the growth area is this business of ancillary liability. So we've talked in those previous cases about the NTEU, for example. That was the Vice-Chancellor was in the witness box explaining how the decision-making happened. In ancillary liability, what we're talking about here is just how broad the net might be cast for a person to be drawn into the proceeding. So Section 362 said that anybody who's involved in the contravention through advising, encouraging, inciting, so you'd expect that the net of involving, being advising and encouraging, would certainly include whoever was in charge of the Human Resources Department. Section 363 talks about officers and agents of associations being liable. Note also Section 550 in the Fair Work Act talks about liability being extended to people who aid, abet, counsel or procure. And the question I'll leave you with at that point is, considering Section 362, who might be involved in advising, Section 550, counselling, aiding, abetting, etc. Is there any reason, for example, that a lawyer, an in-house lawyer, might not find themselves drawn into the court proceedings as a person who has been involved in the contravention? So quite interesting reading for this week. I hope you do enjoy it. Certainly concentrate on the latter part because it is certainly said to be very much a growth area of the law in this particular area. People taking adverse action against an employee exercising a workplace right. Now next week we'll have a look at, be a little bit shorter, the first of 2 weeks dealing with termination of employment contracts. Thanks for listening.